Welcome back, I'm Zane and you're watching Minding Your Business, where what we focus on grows. In today's video, I want to talk a little bit about Ye, also known as Kanye West, and his partnership with Adidas, because while many people were focused more on the antics behind what led to the separation between Yeezys and Adidas, this actually made for a valuable lesson about joint venture partnerships as well as contract law. And what's this lesson? I want to focus on what you should know about entering into a joint venture partnership, some of the legalities behind that, and what it could look like for you and your business. And of course, before we get started, please be sure to like this video if you find any value in today's content, and consider subscribing as well as turning on your bell notifications to be alerted of future videos. Also, while we're going to be talking about a few legalities, let me share a quick disclaimer that I am not an attorney, and what I'm sharing in today's video is not legal advice. Please be sure to consult with a practicing attorney before engaging in any legal transactions. When the news broke of Adidas, along with many other brands to include Gap and Balenciaga, deciding to part ways from Ye and his brand Yeezy, the story went viral, and it seemed like this is all what people were focused on, which I still don't understand to this day, because people were really going back and forth, wasting countless hours of their lives trying to stick up for this man who once said slavery was a choice. However, while people were going back and forth about how these companies need Kanye and that Adidas was stealing his products and so on and so forth, let me break the backstory down while explaining the structure of a joint venture partnership. In a press release from June of 2016, Adidas announced that they were entering a partnership with Kanye and his Yeezys brand in the purpose of selling footwear, apparel, and accessories for all genders across street and sport. Also, as stated in this release, they recognized the influence, the success, and the global brand power of this alliance by making history as the most significant partnership ever created to redefine the future. This alliance formed a joint venture partnership where two or more entities, or in other words, two or more companies, will come together in a purpose of a common goal or mutual benefit, whereas in a general partnership, two or more individuals can come together under one entity, meaning they will partner under one company in a pursuit of a common goal or purpose. And while we don't know all of the details of what was stated in their agreement line by line, here's what we do know. Adidas is listed as the sole owner of all design rights to Yeezy's existing as well as previous products in new colorways under the partnership as stated by the company. Adidas also owns the copyright to both Yeezy's Boost 350 version 1 and Yeezy Boost 350 version 2, which was both filed back in 2017. If you're wondering why Kanye agreed to allow Adidas to own the design rights, is probably because what was supposed to be a long-term partnership agreement until year 2026, Kanye was probably just coming to the table with the vision behind the line and what it could look like on a larger scale. And with Adidas having the volume capacity and the expertise in designing and manufacturing shoes, clothing, and accessories, they were able to bring his vision to life with the mutual benefit of creating a new wave in the fashion industry and an influx of sales for both parties, allegedly. Which is also probably why Kanye didn't want to listen to Sway by going independent with his clothing line.
Why don't you empower yourself and don't need them and do it yourself?
How, Sway?
Take a few steps back to go.
You ain't got the answers, man. You ain't spent $13 million of your own money trying to empower yourself.
Yeah, but I spent hundreds of thousands and putting out clothing lines at a smaller degree. All I'm asking you,
and it ain't no Ralph though. It ain't Ralph level.
Let me ask you this: I'm asking
what's the name of your clothing line? We don't know.
Allegedly again. And if you can recall, a few months ago, Adidas announced the release of their Adidas Q shoe, and a particular person became very upset, saying how the company stole their designs because it looked very similar to their own. And the internet went crazy while continuing to defend this person. But explain this to me. How can a company steal anyone's designs that they don't own? Do y'all remember this? And I actually posted about this on my Instagram during that time as well, because while Adidas could have extended a conversation about the shoe design with their partner, a conversation wasn't really necessary based on the design rights. Again, for all the people in the back, someone can't steal something from you that's not yours. Now, in a normal case, if a person comes up with an idea or a concept and took it to the market, then yes, they automatically own the IP for it, which is their intellectual property. And if they wanted to take the extra step to have it protected, then they could file for a trademark, copyright, or a patent. And quick sidebar, this is something I actually talk about in my LLC course, but in greater detail, because knowing this kind of information is very important when it comes to not only making sure your LLC structure remains protected, but your overall operations as well. So if you want to check that out, you can find the link in the description box to learn more. However, when you sign your rights over to another party, then it's no longer yours to claim. Here's the thing. If you agree to provide a certain skill set in a joint agreement for the exchange of brand awareness, profitability, or whatever you're looking to gain, while knowing that you won't own the rights to any of the product designs that you come up with, no matter whatever else role you play in that agreement, you cannot be upset when you see what looks like a design that you have created being duplicated elsewhere in your partner's company. Now, Kanye does own the Yeezy brand itself, and a trademark that was filed on January 12th of this year, which was registered for the purposes of clothing to include anything from tops, bottoms, shoes, hats, gloves, etc. So, under the separation of Yeezy's and Adidas partnership, moving forward, Adidas or any brand that cut ties with the company will no longer be able to sell Yeezy branded products in their company if they shared a similar agreement. But speaking on Adidas specifically, since they own the design rights for all the products that they have made together, they will be able to continue selling the design of what was formerly known as Yeezys, but will have to rebrand it under a new name. So hopefully that brought forth some clarity, and while Adidas may have taken a financial hit, they will survive, as would Ye. The thing that really got me is that people were debating over details that they truly didn't know nothing about. From what sounds logical to what's actually detailed in a contractual agreement between two or more parties are very different arguments, especially in a court of law. And anytime you are considering entering into a joint venture partnership or a general partnership, I always suggest knowing exactly what you're getting yourself into before you get into it. Because like I always say, when you walk into situations blindly, you can easily be led down a wrong path. And while there are many amazing benefits with forming a joint venture, from accessing new markets, pooling resources together, technical expertise, and so much more, one of the biggest benefits is that you can remain in control of your own operations as a separate entity from your partner, and whatever pending debts or liabilities that they may have outside of your partnership won't be your responsibility to resolve. Though, with every benefit, there are also downsides, especially when the roles and responsibilities between all parties involved aren't clear, or parties don't remain on the same page, which can cause some disputes. But before you decide to enter into a joint venture with another company, you should first get clear on what all parties are bringing to the table, or what can they bring to the table, because with any partnership, there must be some sort of mutual benefit. You should question, what does this company possess that can benefit me with carrying out a particular mission or accomplishing a goal? From Adidas' partnership with Kanye, it seemed like Kanye was bringing his influence, creative ability, and brand power, while Adidas was bringing their expertise and manpower as an already established brand in the athleisure market. Next, you should assess each party's weaknesses and strengths to properly determine who's going to be responsible for what under the partnership. And finally, you should discuss all contingencies that can happen and how it would be handled, whether there's a loss of key staff members due to an unforeseen event, equipment shortages, new regulations that can interfere with your deliverables, changes in market conditions, or whatever the case. Every possible scenario that can hinder your performance in carrying out your roles and responsibilities successfully need to be considered. And when it comes to drafting a joint venture agreement, which should specify the perimeters of each party's involvement in a legal binding contract, it should mention your ownership stake, the specific duties of each partner, as well as their contributions to the partnership, whether it's goods, services, resources, equipment, or money. And there needs to be a clause for the distribution of profits. Also, your agreement can detail its management structure, allocations of profits and losses, and most importantly, a dissolution clause or a clean exit strategy. And please note, there's no right or wrong way to structure a joint venture agreement. You just want to make sure that you have all of your bases covered to reach your end goal successfully without any major conflicts. Because again, when you walk into situations blindly, you can easily be led down a wrong path.
Learn something from this!
Signing out.